You sued your doctor for medical malpractice, and now during the course of your lawsuit, you are going to be asked questions by the defense attorney in a process called a deposition, a pretrial question and answer session. During the course of questioning, you don't remember the answer to a particular question. You want to turn to your attorney and ask him, hey, can you remind me what my answer was when I told it to you the other day? Can you do that? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, you cannot do that. You cannot turn to your attorney in the middle of being questioned and say, hey, can you remind me of the answer that I gave you a few days ago? It's on the tip of my tongue. I just don't remember it, and I want to be as truthful and as honest as possible. The answer is no, you cannot do that. And you might be thinking, why not? I knew the answer a few days ago when you were preparing me for this question and answer session. So why, if I forget the answer when I'm being asked it, it's not like I didn't know it before, I did, but I just don't remember it on the spot right now. Why can't I turn to you and ask you for that information? Why can't I pull out my phone and search for that detailed information that I know I have stored on my phone? Why can't I pull out my notebook and look it up because I know I have notes about what occurred here? The answer is no, 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 and no. The purpose of a deposition is not for you to go ahead and recite all the details of what happened to you. The purpose of being asked all these hundreds, if not thousands, of questions by an attorney, by the opposing lawyer, in this examination before trial, is to find out what you know. It's to find out what you remember. It is not a test. And it is not your opportunity to tell the opposing attorney every single detail of every single event that involved your particular matter. That's not the opportunity, and that's not the purpose of this deposition. Instead, the purpose of you, the injured patient, the injured victim, answering these questions is to answer the defense lawyer's questions. Now, there will be instances, without a doubt, where you will simply not remember an answer to a question. And you know what you say in that instance? I'm sorry, I knew the answer a few days ago, but I just don't remember it now. That's fine. In fact, that's perfectly okay. There are instances where the opposing attorney will say, fine, we will leave a space in the transcript, and when you get a copy of this transcript back to review its accuracy, if you recall that information, please insert it at that time. And we'll say, fine, we'll do that. But the fact that you did not remember is not going to harm your case, because no one can be expected to remember every single detail of every single instance involved in your particular matter. I will share with you that if, in fact, you did remember every single detail, it would be highly suspect. I shouldn't say highly. It would be quite suspect. Why? Because then someone's going to think that maybe you memorized all the details that occurred. Maybe all the details that you're reciting has been recited over and over and over again in order for you to remember it. Maybe you're simply recalling something that you've been practicing repeatedly over and over again, and this is nothing more than trying to remember what you recited to yourself endless amounts of times. Maybe it's something that you told yourself and have been telling yourself for the past few years leading up to this question and answer session. Whatever the reason, the fact is, if you don't remember something, you simply say, I'm sorry, but I don't remember. Now, if you get to trial and you are asked the same question, you may remember at that point. And if they cross-examine you and say, I don't understand, a year earlier when you were asked this question during your deposition, you didn't know the answer. And your response may be, you're absolutely right. I totally forgot it. It was on the tip of my tongue, but I didn't remember it at that moment. However, now as I'm preparing to get ready for this trial, now I'm refreshing my memory and I do realize that the answer is X, Y, and Z. Importantly, going back to the title of this video, you cannot turn to your attorney to ask him for any information about the actual substance of an answer. You can't do that. Either you know the answer or you don't. It's that simple. If you do know it, fine, you tell the attorney you know it. If you don't know it, you tell the attorney, I'm sorry, I don't know it, or I don't recall it at this moment. That's it. But why do I share this quick information with you? I share it with you because some people have the perception that if they get stuck on a couple of questions during your question and answer session, known as a deposition, that they could turn to you or go out in private and say, hey, what's the answer to this? No, that's not how it works. Your attorney is not there to provide you with the answers. Your attorney is there to guide you and to protect your rights so that now, If you remember, fine, you tell the attorney. If you don't remember, you say that as well. I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.